All right. Good morning, good evening, good afternoon. We are apparently live. This is going to be something of a repeat from last night. Apparently, YouTube decided to delete my last video because I showed personally identifiable information. So hopefully, this will be a little shorter on the BZ side of things, and a little bit maybe if you guys are entertaining, if you guys have interesting things to talk about, then I'll stay on a little longer. Otherwise, we'll just call it when I get done with the BZ's post office versus more 2001 issue. I am having some libations. It is a Saturday night. I've worked hard doing dumbass things all day in 110-degree heat. So I don't feel bad about having a libation. The first thing I want to say is that BZ is being he's lying. He's lying in the way he is presenting this. He is suggesting when he says take a look at post office versus more 2001, he is suggesting that there is something that counteracts my narrative that places all of the cases, all of the citations, all of the statutes that I have presented, it somehow casts doubt on them. It's a common tactic you'll see with sovereign citizens, with flat earthers, with all sorts of those wonderful people who want you to prove to them that they are retarded. Of course, they'll never accept that they're retarded. There's no amount of evidence that you could present to them that will make them accept that they are retarded. So usually the best course of action is to just say, whatever, dude, and walk away. But that's not what I'm here for. BZ and his erstwhile cohort, Michael Eline, are busy spreading misinformation, dangerous misinformation that could, in theory, get people arrested. And, if you go into a post office and you want to get arrested and you're aware of the potential that you will get arrested for a violation of state law, if you go in there knowing that and you decide that you want to do it because you want to be a First Amendment activist and it's important to you to be able to film in a post office for whatever fucking reason that I don't understand, if that is your thing, then I support you. Go ahead, do your thing, go out there, get arrested, or maybe try to get arrested or whatever. As long as you go in knowing the risks that you're facing. But having fat retards like BZ and TBI retards like Michael Eline going around spreading deliberate false information is annoying to me. Now, Michael Eline stands not to get harmed by any of this. Because Michael Eline's not going out and doing post office audits. Michael Eline's not putting his neck at risk. He is sitting back from the comfort and safety of his probably gaming chair, hiding behind his giant phallic black microphone that he keeps tantalizingly close to his lips, while he expects stupid auditors to go out there and take all the risks for him. And then he will ride in like a white knight and champion them in their lawsuit against the evil and bad government. BZ, on the other hand, is a coward. I don't know how else to phrase it, and he will buckle like a seatbelt. Not that he could actually wear a seatbelt; he's way too fat to wear a seatbelt. But metaphorically speaking, I know he doesn't understand metaphors, but metaphorically speaking, BZ will buckle like a seatbelt at the first sign of pressure. He is not going to challenge the authority. Why do I hate auditors? I went out to dinner with Nasty Nathaniel. I went out to dinner with Pink Camera Magic. I went out to dinner with First Amendment tests. I forget what his screen name is. He hasn't made a any audits in a while. So yeah, I don't know why you think I hate auditors. And you know what? Like Jeff Gray. I mean, Jeff Gray. This is a blanket invitation. If you're ever out in California, hit me up, and I'll take you out to dinner. I'll buy you a nice fat steak, and we'll hang out, and then I will join you, Jeff Gray, as we walk around with "God bless homeless vet" signs in California. So, that being said, this is dishonest. What he's doing here, what BZ Watchdog is doing here, is dishonest. He is giving us a case name that doesn't exist, and he is giving us a date. So it looks, at first blush, this looks like it could actually be a case, but it's not. If you actually Google post office versus more, you don't find anything. You find more versus the United States Postal Service, but you never find post office versus more. I mean, if you're not retarded, you would know that post office is not the name of the United States Postal Service. And so they would never sue anybody under the name post office, because that's not their name. They would sue under their name, United States Postal Service. So that's number one. So you'd have to look up United States Postal Service versus more, and you don't find it. Why? Well, a quick leak of the goods is because it's the people of the state of New York versus Don Moore. Now, how do we get there? How do we get to people of the state of New York versus Moore? Well, the first thing you do is you Google U.S. Postal Service versus Moore, and you look for something around 2001, and you find this case. This case was filed in 2001. You see it's 01-CV. This was filed in 2001. We could actually check the this right here, and you can see that the complaint was filed in 2001. So I'm not playing hide the ball. This is 2001. You're live. I've been drinking. What could go wrong? We could touch tips, I guess. Would that be wrong, or would that be right? Jason says, Merber, you and Kate having love issues. Haven't heard you mention her name in a while. I actually mentioned her last night because she does have epic boobs, and I love and adore her boobs. So, Merb, I just want to know if you now believe in the audits, which side you on, still trying to cook auditors. I am now and have always been on the side of the First Amendment. I do wish that auditors would understand the First Amendment. I do wish they would understand the difference between getting arrested for filming and getting arrested for being an asshole, doing things like disorderly conduct, etc. I wish that auditors would be better informed about the state of the law. But as long as they're acting within the bounds of the law, I have absolutely no issue with them. And if they are breaking the law, as long as they're breaking the law with peaceful protest by just filming, I would support that too. I mean, I don't necessarily think that there's any valid reason to try to film inside of a post office, but if that's what your heart is set on, and you want to peacefully protest to try to change the rules on filming inside of a post office, and I just don't like, I'll support you on that. Like, great. It doesn't bug me. It doesn't bug me. It does bug me when auditors do things that end up restricting their right to film and the right of others to film. I wouldn't necessarily go as far as Biff Thundermuffin, but it does irritate me when they don't know what they're doing and they do things like for example, when you don't have any business in the Social Security Administration office, to go into the Social Security Administration office knowing that people there are giving out their personal private information, that really bugs me. That irritates me, because that impacts the ability of the government to conduct business in an efficient manner. And it gives the government an excuse as to why they're not conducting their business in an efficient manner. And so all of a sudden now we can't just say, government, you're just completely inept at what you're doing, and maybe you shouldn't be doing it, because the government can say, well, gosh, it wasn't our fault. There were all these silly auditors in here coming through. And so it slowed down operations and thus increased operating costs, yada, yada, yada. Greetings from Transylvania. Mr. Kist 78, Nasty Nathaniel does a great vampire. But back to the issue at hand. So we had BZ Watchdog asking us to look at Post Office versus Moore 2001. Obviously, that doesn't exist. However, we found Moore versus United States Post Office, which I have confirmed was in fact filed in 2001. So I think we're on the right. Track. Now, I read this particular decision, and this is where Don Moore, and some other people are suing the United States Post Office for various violations. But the real crux of what they're suing the Post Office for is for a Bivens action. That's an action that is not, there's no statutory grounds for it. You're suing the federal government basically under a common law cause of action for violating the Constitution, or you believe they're violating the Constitution. Now, Bivens actions are highly disfavored. They're incredibly disfavored. Basically, if you're not within one of the existing Bivens exceptions, you're not going to get heard. The case is going to get dismissed. But they sued under Bivens, and they also sued under 42 USC 1983. Now, for those of you playing along at home, I'm sure you remember that 1983 cause of action allows you to sue state actors. And I'm using the word state specifically to refer to actors in the 50 states and their sub agents in the counties and cities, right? It does not let you sue. You can't sue a federal employee under 1983. So that's an issue. You can't sue the post office, which is federal, under a 42 USC 1983 cause of action. And you really can't sue them under a Bivens cause of action unless it's under one of the limited exceptions. I would not let my dick near BC's mouth, because looking at that man, he has no problem eating anything. So there we go. So it's a failed cause of action. They're going to fail. They did fail. Again, to cut to the chase, they ended up losing. They ended up appealing, and there was a summary order affirming the judgment of the district court, which means that they lost on appeal. Right? So the case went nowhere. But the allegation was made in here that on the morning of March 9th, 1999, Don Moore was arrested for trespassing by the state police, by the New York police. He was arrested by the New York State Police. And then again, he returned again a year later, on March 14th, 2000, and he was once again arrested for trespassing, both times, by the New York State Police. Now, is this fact? Did these things actually happen? I don't know if they actually happened. This is what he's alleging. These are the facts. So on a motion to dismiss, the court is going to basically list the facts in favor of the petitioner, the plaintiff. The plaintiff is looking at getting his case dismissed. So basically, the court is going to construe all the facts, all the allegations in favor of the plaintiff, if at all possible, right? Because this is a motion to dismiss. None of these facts have been tried. None of these facts have been determined by a finder of fact. There's been no jury. There's been no trial. These are all just looking at the pleadings. Plaintiff said X. So I'm going to assume X to be true for the purpose of this motion to dismiss. You fully understand 1983 because you're an inmate. Well, no offense, all things now, but I'm going to press X to doubt. Yes, Ed Wickham, Don was a disgruntled former USPS employee. So he was arrested twice between March of 1999 and March of 2000. Twice, both times for arrest. Now, he alleges that the conviction was appealed to the Onondaga County Court, and on November 1st, 2000, the court set the conviction aside and vacated the protection order due to insufficient evidence. That is what he alleges. Now, that's where the problems come in. And here are the problems. Number one, I went to the Onondaga County website and I looked up Don Moore. And I found Don Moore. And this is Don M. Moore. If you go to the Onondaga County website and you look up, you spend the money on search. You can do a free search, by the way. You can do a free search. You just can't look at the documents. But you can do a free search. You can go there whenever you want. Onondaga County website, Onondaga County Court. The actual, hold on a second. Let me look at my history. I'm not going to show this because I think this is what got it hit for my last stream hit for the personal information. But it's COTT hosting, COTThosting.com/NY Onondaga external. And then maybe / other things. But this is COTThosting.com. This is the official website. It's the Onondaga County of New York County Clerk's website. I did, in fact, search Don Moore from, I think, 1970 to 2024. I could only find one. Actually, hold on a second. Let me, I don't know if I should share this. I don't know if I should share this because I think that's what got me in trouble last time. But I searched from 1970 to 2024. The first record that populated was from 1987, which was Donald Moore. That is, I believe, the father. Let's see. I believe that was the father. No, I guess John and Carolyn Moore. So I don't know who Donald Moore is. Donald W. Moore. It was I don't know. But there's also a family court issue. Those were back in the 80s. The only criminal record that pops up from 1970 to 2024, the only criminal record that pops up is for Don M. Moore. It is in 2000. And no, it's just 2000. It's just in 2000. That's when the appeal was filed. And it's CO-2000-000104-A1. And that's the people versus Don M. Moore. And so I spent my good hard-earned money on the documents, all of the documents. There's only 4 pages of documents, 3 documents in total. But because I spent my hard-earned money on it, I did have to watermark it because that's what Shiz told me. Since when is a post office a traditional public forum? I don't believe it is. I would hazard a guess that it is, at best, a limited public forum in some areas of it. But there may be a post office somewhere that is a traditional public forum. You're right. You're right, John Anderson. I should have a better understanding of the law before giving legal advice, despite the fact that I have a law degree and I'm sure you don't. And despite the fact that I'm aware of multiple cases where people have been denied the right to film in a post office, and courts have never held, show me one time where a court has held that you have an absolute right to film in a post office, that a post office is a traditional public forum. In fact, United States versus Coquinda held that at least as to the sidewalk leading from an internal sidewalk leading from the parking lot to the post office itself, from the post office parking lot to the post office itself, that part or that sidewalk was a non-public forum. Non-public forum. So that's USV Coquinda, I believe. And we have some differences of opinions. Johnny Bravo must be really fucking horny if he's willing to hit shiz. Anywho, and anyway. So this is an appeal that was filed in January. We know that it was filed in January because this is the notice of appeal that was filed, and it's dated January 14th, 2000. So this was filed after the first trespass arrest, the first alleged trespass arrest, and after the and before the second trespass arrest. All right, so John Anderson wants to continue. James Freeman has already demonstrated why you have a right to film in a post office. You should learn from Freeman. He's knowledgeable about these things. Freeman doesn't have a law degree, and Freeman cannot demonstrate why you have a right to film in a post office. Here's the problem, John Anderson. If I told you that you have an absolute right to not wear a seatbelt in the state of California, and to demonstrate this absolute right to not wear a seatbelt in the state of California, I drove around in my car for 24 hours filming myself not wearing a seatbelt. Would I have demonstrated that you have a right to not wear a seatbelt in the state of California? No. I would have demonstrated that it's possible to drive around for 24 hours without getting pulled over by the police while not wearing a seatbelt. But if the police pull you over, and if they decide to write you a ticket, and if you go to court, well, then there's the problem. James Freeman has so far unsuccessfully attempted to sue the 7th Judicial District Court of the state of New Mexico over various allegations that he has made about a lack of due process. James Freeman, even James Freeman, Mr. Anderson, even James Freeman, who was told explicitly that he could not film inside of the court hearings, again, the sheriff isn't enforcing, for whatever reason, the sheriff isn't enforcing the court's orders on filming in the courthouse. That's, okay. The executive branch has some discretion on what it will and won't enforce, but even James Freeman didn't challenge the orders on filming in the courtroom. He didn't sue the court over that. He sued the court over a lot of things, Mr. Anderson. Like, I'm trying to be nice here, sir. And I agree with James Freeman on a lot of political issues. Like, I think there's too much government, etc. But he has not proven that you have an absolute right to film. You're overly optimistic, sir. But anyway, where were we? So this appeal was taken from the Jordan Village Justice Court, right? And we saw this in the opinion here for the Moore versus United States Postal Service. He says he won, but in this opinion, you will see that the order or the judgment of conviction for trespass is hereby affirmed. The decision herein constitutes the order of the court. So, under a state law, the state of New York, under a state trespassing law, the state of New York arrested Don Moore, tried Don Moore, convicted Don Moore. Don Moore appealed and lost on appeal. I don't give a shit what you think, all things now. And I can't express that any more clearly. I literally don't give a shit. So you're not going to get highlighted anymore, Mr. All Things Now. You're not. Your opinions are retarded, and your shit's all fucked up. So the one decision that we have, there's only one for Don Moore for this arrest. There's only one, and the conviction was affirmed. Now, Don Moore alleged and attached this, what he alleges is a decision in order. He attached this to his complaint. These are pages 21, 22, and 23 to his complaint. You can see here's the civil case number for the federal court up here at the top in blue. Here are some problems with it, though. Number one, there is nothing indicating filed on this. There's just nothing. There's nothing indicating it's filed. If you look at this particular document, or even this particular document, or even this particular document, you see a filed stamp, filed, and filed. So all of these have been filed. You'll notice on the two orders, there is this number down here. This order was filed in 2000, and it's 43F something, at maybe F1 109. And this document, both pages of this document are stamped sequentially, 50F0629 and 50F0630. All of these have the file number down at the bottom. So there is a uniformity to them. You don't get a judgment of the court without it being file stamped. You just don't do it. And this document is not file stamped. There are no file stamps on it. There's nothing to indicate that this document came from a court. In addition, there are some questions. Number one, this particular order alleges that it was made in November 1 of 2000. So this order right here, this is from the first one. The appeal was filed in January of 2000, so it had to be from the first trespass, the March of 1999 case. So that's 9 months to get to the appeal stage. And then from the appeal stage, it takes 2 years and change to get to here is your judgment on appeal, your opinion on appeal. This one is alleged to be from the later of the two, from the March of 2020. And so this one alleges that in about 6 months, it went through trial and appeal. So that's a real problem. It's a real inconsistency. There are other inconsistencies like this signature here. See on the F, it has this down arrow right here pointing toward the dot. You don't see that in this signature right here. There's no downstroke on the F, which looks like a J. There's no downstroke on the F, which looks like a J. There are other issues too, but that's some of the big ones. Like Bleakley is spelled correctly here in People versus Bleakley. Blakely is misspelled here. It should be Bleakley. There's a lot of issues with it. This is something that was attached to the complaint. The file stamped means not lawful. What? Are you drunk, high, or what have you? So So the complaint, in the complaint, he alleges that this is a judgment. And remember, the complaint is allegations. The federal court could take judicial notice of a judgment by a state court or an opinion by a state appellate court. And in fact, if asked to do so, would. It was not relevant, however, for the decision that the Court of Appeals made. It never had to. It was never asked to. It never had to. The court could consider the Bivens motion in the 1983 lawsuit without having to deal with any of these things. Can't prove when this was filed. Are you drunk, high, or dumb, sir? So no file stamps means then not legally binding or lawfully filed, null and void, moot. I'm sure you mean moot. So no file stamp means that it's not actually a judgment. There's no way a judgment leaves the court. There's no way a judgment leaves the court. When the court signs the judgment goes to the clerk. The clerk files it in the official record, and then it goes out. So if it's not filed, if it's filed, there's a file stamp that shows it's been filed. So basically, what happened here was much like Kate Peters. Kate Peter was not the first person to ever fabricate a filing. This Don Moore fabricated, lied, made up a order of the court, a opinion on an appeal, attached it to his complaint, and because he attached it to his complaint, it is one of the facts that the court in the federal case, when determining the motion to dismiss, just accepted as true. Didn't matter. It didn't matter. The defense never had to rebut it. It was a motion to dismiss, and it was based on a lack of subject matter. That's it. It was a motion to dismiss based on a lack of subject matter. Bivens didn't give him the subject matter. 1983 didn't give him the subject matter jurisdiction. The court didn't have jurisdiction to make any binding orders on this, so the court didn't have to determine whether or not any of the facts alleged in the complaint were true. To me, it's like not signing your name, not over the line, and then later claiming that's not your signature. Text yellow goal. I don't understand what you're trying to say, Johnny Bravo. I don't understand what you're trying to say. If you sign a document with an X, if that's your signature, then it's binding. It's your signature can be whatever you intend your signature to be at the time. If the judge had signed this particular document, number one, his signature would match his other signatures. And number two, because it is an order of the court, even though the judge is essentially representing the court at that point, it would be an order of the court. And therefore, it would have to go through all the procedural hurdles that any other order of the court would go through. It would have to go through the court clerk for filing and for being served on the parties, most likely. You know, it's funny, all things now. When you first appeared here, you said, and I want to quote you on this. you said, why did I end up here again? And that's the question that I'm asking, because I don't think that you should be here. You don't seem to be appreciating what I have to say. You're asking me catch 22 questions like how much the government paying you, Merb? And I don't appreciate it. Like I am giving you the insight, the knowledge, the benefit of my experience and understanding and my research for free. And the best that you have is how much is the government paying you? That's kind of disrespectful. I normally don't allow people to come into my house and disrespect me. Now, I'm being very generous tonight, so I mean, you can always go somewhere else. If you don't like me, why are you here? Is really what I'm trying to say. If you don't like me, why are you here? Just leave. Anyway, it doesn't look like we're going to get any useful interaction tonight. So that's really all I had to say. By the way, to round out this little deal here, you noticed that BZ never did provide a quote. And then we have this right here. This is from a day ago. He never appears to have watched the video that I did last night. So he says, shots fired at me again. I was sending you a case and wanted to hear your opinion, argument on it. Seriously, as an open-minded person, I haven't even heard this new video. Now, again, this isn't very, very genuine, right? He didn't send me a case. I asked for a citation. He never gave it to me. So then I point out, you never sent me the citation. And he responds, I thought I did. Sorry about that. That is playing stupid. That is a classic maneuver that people like to do to avoid having to actually do the thing. Put your hand behind your back. I'm trying to put my hand behind my back. Well, no, you're talking about it. You're not actually putting your hand behind your back, right? You hear stupid people doing this kind of maneuver in an attempt to make it seem like they're complying, or make it seem like they're being genuine, make it seem like they're being honest, and yet they're not. So when I said last night, and what I'm saying tonight, that BZ isn't an honest interlocutor, he doesn't actually care. He's not going to believe the evidence that's being presented. He's going to play. He's going to put something out there. And I strongly suspect, and I have said this previously, I strongly suspect that the reason why he doesn't give me a citation is probably twofold. To a lesser extent, he doesn't have a citation and probably doesn't understand how to give a citation and hasn't read the case and just heard something about something that he's vaguely remembering. But to a greater extent, I would suspect that he's not giving a citation, that he's not giving something identifiable, because now he maintains plausible deniability. He can always allege that he has a case that undermines my position, undermines all of the cases that I presented, undermines all of the statutes that I presented, undermines all of the evidence that has been presented. And yet you can't see it because he's never produced it. It's like that Mormon guy who had to look in the hat, and if anybody else looked in, like, they wouldn't be able to see it. Joseph Smith. It's that kind of nonsense. Like I can't show you my evidence, and the reason why he can't show his evidence is because as soon as he does, he knows that it's going to get sliced and diced and torn apart, just like this particular case, this Moore versus United States Postal Service, where the plaintiff alleged that he had his trespass conviction overturned on appeal, and yet it was not overturned on appeal. He lied about it. There's no evidence anywhere that it was overturned on appeal. And so all of it sounds like bullshit. I would suspect that Beasy would probably tell you that he just has a glandular problem or something like that. Anyway, that's all I got for you today. Thanks for watching. Have a great evening.